A bitter January 2022 night, a Canton bar crowd, a snowstorm, and a body in the yard. The Karen Reed case began with the John O'Keefe death that shook a Massachusetts town and set off a national debate. Prosecutors said Reed struck O'Keefe with her SUV, then left. Reed said she dropped him at a friend's house, and that something happened inside, not on the street. The stakes soared fast. This became a high-profile Massachusetts murder trial with police misconduct claims, a fired investigator, and deep questions about trust in local institutions. The arc has been messy. A 2024 mistrial left the story open. In the 2025 retrial, the jury cleared Reed of murder and manslaughter and found her guilty only of OUI, with 1 year of probation and entry into the OUI 24D program. Here, what you'll get next without spin. A clear timeline, the key evidence that moved jurors, the trial twists that fueled the mistrial and retrial, and the Karen Reed verdict 2025 in plain terms. We'll also look at what this outcome means for the community and for trust in the process. If you're trying to make sense of the John O'Keefe death and how we got here, you're in the right place. The night John O'Keefe died, a simple timeline that matters. What happened in a few dark, cold hours set the course for years of courtroom fights. Keep the sequence clear and the conditions in view. The snow, the clock, and a single drop-off point shaped everything that followed. From bar to drop-off, who, where, and when. The night moved fast, then went quiet. Here is the clean, simple arc that matters. Around midnight, the night out wrapped up and the roads were slick with fresh snow. After 1 a.m., the drive toward Fairview Road began in low visibility and poor traction. Near 2 a.m., the drop-off outside a house on Fairview Road happened. Karen Reed said she left John O'Keefe there. The storm kept building. Plows had not cleared side streets well, and snow piled up on lawns and curbs. Before dawn, calls and searches began as concern set in. Around 6 a.m., the scene outside was discovered and 911 was called. The snowstorm is not background noise. It cut visibility, made braking harder, and slowed any response. It also covered surfaces, mixed tire tracks, and hid clues. The drop-off point sits at the center of the case. If O'Keefe was hurt outside, the street is the scene. If he was hurt inside, the drop-off is only a handoff, not the crime scene. Both sides built their story around that curb. Discovery in the snow, and the first response. Around 6 a.m., John O'Keefe was found on the snowy lawn near the drop-off spot. Karen Reed placed the 911 call. Police and EMS arrived soon after. Key conditions framed what responders saw. Snow had drifted and partly covered him. The air was frigid. The lawn held layers of frozen crystals and packed snow from the night. He had been outside for hours, from the overnight drop-off to dawn. Cold exposure, limited light, and a snowy surface complicated the first moments and any quick read of the scene. Timing matters. A pre-dawn discovery after a winter night means fewer passers-by, slower driving, and fewer clean footprints. The storm also affects impressions about tracks, shoe prints, and how fast responders could move. Two competing theories: crash outside versus attack inside. Too clean, clashing stories guided every step. State theory: Karen Reed hit John O'Keefe with her SUV near the drop-off. They say impact injuries match a vehicle strike, the tail light damage lines up, and he was left outside in the cold. Defense theory: the fatal injuries did not come from a car on the street. They say he was harmed inside the house, then ended up outside. They argue the wounds fit an indoor altercation, not a roadside crash. These theories shaped searches, evidence fights, expert choices, and how jurors heard every fact. Once you choose a story of where the harm happened, you choose what matters most at the scene. Evidence that shaped the case, what jurors kept hearing. Across both trials, jurors kept circling the same puzzle pieces. A broken taillight, snow that hides more than it reveals, phone data with messy timestamps, and injury science that can point in two directions. Each thread mattered on its own, but the gaps and conflicts between them mattered even more. Vehicle clues, snow and phone data. The SUV was a constant presence in court. The right rear taillight on Karen Reed's vehicle was broken. Jurors heard that no taillight pieces were found on the lawn or street where John O'Keefe was discovered. Forensic checks also did not find dirt or biological material inside the broken taillight housing. Other body panels showed no clear dents or long scrapes, which kept the focus on the rear right area. A 5:07 a.m. clip showed Reed's SUV pulling close to O'Keefe's parked vehicle. The defense said a bump happened then. Prosecutors said the timing did not match a fatal strike. Without taillight shards at the scene, both sides argued what the absence meant. Was it proof no crash happened on that lawn, or a sign the storm hid the pieces? Snow complicates everything. Fresh accumulation can blanket fragments, blur tracks, and soften impact marks. Plows and tires push debris into windrows. Overnight frost can change how surfaces record contact, then trap or erase it by morning. Jurors had to think like winter searchers, not just lab techs. Phone data filled many hours in court, with important limits. Location services often place a device in a zone, not on an exact spot. Cell site data shows proximity to a tower, not a precise street corner. GPS can drift in storms or near buildings. Phones also move on their own when left in cars or on counters, and gaps appear if settings restrict location logging. 2 digital points stuck out. A contested Google search about how long it takes to die from cold exposure. The defense said it was around 2:27 a.m. Prosecutors said it happened after 6:23 a.m. once the body was found. That gap is not small. It swings the narrative from foresight to shock. Call logs and pings that set rough windows for who was awake, searching, or driving. Helpful, yes, but not exact. Jurors had to treat timestamps as guideposts, not GPS pins. Forensics and injuries, what science can tell. The injury science did not sing a single note. Experts described head trauma consistent with blunt force. That can come from a vehicle strike or from a backward fall onto frozen ground. On a winter lawn, packed snow can be hard as a curb. Ice edges can cause sharp splits. The pattern on its own did not lock in one cause. Cold changes the body in ways jurors had to weigh. Hypothermia slows bleeding, which can make injuries look smaller at first glance. Body temperature drops, which blurs time of death estimates. Lividity and rigor can set differently in freezing conditions. Snow can abrade skin, mask blood spatter, or dilute it. All of that muddies a clean read of impact, timing, and sequence. Time outside matters too. Hours in sub-freezing air can layer injuries and exposure. A person can be injured, then later suffer cold-related damage that complicates autopsy findings. The question of when a head wound occurred sits next to how long the body endured cold. Jurors heard both sides use that overlap to support their theory. Texts, calls, and relationship context. Messages and calls gave jurors a window into mood and motive. They also demanded careful reading. Couples text in shorthand, sarcasm, and heat-of-the-moment bursts. A midnight argument can sit next to a morning apology. Without tone of voice, emojis, or context, words can feel sharper or softer than intended. These are the common ways messages were used in court. Proof of strain, like jealousy or anger. Proof of care, like check-ins and plans. A timeline of who was awake, worried, or searching. A record of alcohol use or stress late at night. Jurors had to weigh 3 filters. First, selection bias, since neither side shows every message. Second, timing, since a heated text hours earlier does not prove a later act. Third, intoxication, since late-night words can be blunt and unreliable. Respect for the people involved matters here. Relationships are messy, and screenshots rarely capture the whole story. Expert witnesses, conflicts, limits, and takeaways. Experts did not agree, and that mattered. Crash reconstruction specialists debated whether the taillight damage matched a human strike or another contact. Forensic pathologists split over whether the head trauma fit a vehicle hit or a backward fall. Each side used models, measurements, and photos to argue probability, not certainty. Cross-examination became the stress test. Lawyers pressed experts on assumptions in their models and simulations, the margin of error in measurements, how snow and cold were factored into conclusions, chain of custody, and the quality of scene work. Data quality set the ceiling for expert confidence. The lack of taillight debris on the lawn, incomplete testing in some areas, and questions around evidence handling all trimmed certainty. A fired investigator connected to evidence collection gave jurors more reason to doubt the neatness of the process. 3 clean takeaways kept surfacing. Expert opinions depend on inputs. Weak or missing inputs mean softer conclusions. Winter conditions can defeat textbook methods. That is not a dodge. It is physics. When experts split, jurors look for anchors, like reliable timestamps or physical proof that cannot be explained away. In the Corinne Reed case, those anchors were rare. The science pointed in 2 directions, the phone data had holes, and the snow kept its secrets. That steady drumbeat of uncertainty shaped how the jury weighed reasonable doubt in 2025. Twists and turns, mistrial, viral attention, and a fired investigator. The Corinne Reed case did not move in a straight line. A deadlocked jury, massive public attention, and the removal of a lead investigator reshaped the fight over facts. These turns raised fair questions about proof, process, and pressure, then set the tone for the 2025 finish. Why the 2024 trial ended in a mistrial. The first trial ended in early July 2024 without a verdict. The jury told the judge they could not agree. After days of work, they remained split. The judge declared a mistrial. A hung jury means the jurors cannot reach a unanimous decision. It happens when people weigh the same record and come to different views. Conflicting expert opinions, gaps in the timeline, and disputed inferences often drive that divide. When science can point 2 ways and credibility is in question, stalemate becomes likely. A split jury cuts both ways. For prosecutors, it shows parts of their case persuaded some jurors. That signals where to sharpen themes, tighten timelines, and clear up science in a retrial. For the defense, it proves reasonable doubt took root. That encourages a deeper push on weak links, chain of custody issues, and the limits of winter scene analysis. Both sides carry lessons forward. The evidence does not change, but the framing does. A mistrial is not a win or loss. It is a reset with a blueprint for what moved people and what did not. Social media, public rallies, and courtroom moments. Social media turned a local trial into a national saga. Hashtags surged. Videos of testimony, yard scenes, and hearing clips spread fast. Supporters organized online, then showed up in person. Pink shirts, chants outside the courthouse, and constant live updates kept the story in the spotlight. That attention brought energy and risk. Public rallies can build community and accountability. They can also create noise that seeps into the process. Jurors are told to avoid coverage, but headlines, push alerts, and viral clips are hard to miss. Witnesses may feel pressure from cheers, criticism, or relentless scrutiny. Judges respond with strict instructions, and at times, tighter rules on comments by lawyers and parties. The effect is real. It raises awareness and surfaces new questions. It also threatens to color perception, inside and outside the courtroom. It makes the work of finding a fair jury harder. In a case already full of doubt, the volume of outside voices added another layer to manage. A lead investigator is fired. The lead investigator was fired after misconduct allegations tied to his conduct during the case. Internal reviews found behavior that broke department rules, including messages that showed bias and poor judgment. His removal did not prove evidence tampering. It did, however, cast a long shadow over the early stages of the probe. This change shook confidence in the process. When the person guiding key steps loses credibility, people question what those steps produced. It raised fair concerns about how interviews were handled, whether notes and reports captured facts cleanly, the care taken with collection, storage, and testing. Trust is the backbone of any investigation. Once cracked, it is hard to repair. The firing invited closer scrutiny of evidence handling and decisions made in the first days. It also gave the defense a stronger platform to argue that doubt was not only reasonable, it was earned. Inside the 2025 retrial, what changed and why it mattered? The second trial felt sharper, harder, and more focused. Both sides cut away fluff and aimed at the few points that could move a jury. New limits from the judge, a retooled defense table, and clearer lines on what the SUV data proved all changed the tone. The story did not get simpler, but the choices did. New testimony and cross-exams that stood out. Several moments shifted the ground under both sides. Some helped the defense build doubt. Others helped the state hold a clean line. A former juror from the first trial, Victoria George, joined the defense team. She did not testify, but her presence shaped strategy. The questions sharpened where jurors struggled in 2024, like timing, taillight debris, and who had motive to move a body. The judge limited defense claims against specific third parties. The court barred a direct blame of Colin Albert. That ruling forced the defense to frame its inside-the-house theory around process failures and patterns, not a single named attacker. Cross-exams on injury patterns hit familiar beats, but with tighter focus. Defense experts pressed on how head wounds can come from a backward fall onto hard, frozen ground. Prosecutors pushed back with the broken taillight, arguing it matched a strike near the curb. Testimony around a Google search about cold exposure stayed hot. The defense pointed to a late-morning timestamp after the body was found. Prosecutors argued it could have happened earlier. The spread in time left jurors with a choice between panic and pre-planning. Why it mattered? The defense gave jurors a clear off-ramp from the SUV theory. No taillight shards on the lawn, uncertain phone timing, and a fired investigator helped them argue that nothing locked the SUV in as the fatal cause. The state kept a steady drumbeat on alcohol, anger, and impact injuries. When science split, they argued common sense. A broken taillight, a body in the snow, and a night of drinking fit their story. The defense timeline, doubt around the SUV theory. The defense put time and conditions at center stage. They argued the clock, the storm, and the data did not tie Canton Reed's SUV to a fatal hit. Here is how they chipped at certainty. Timing windows were wide, not tight. Phone pings showed zones, not precise dots. GPS drift in a storm, tall houses, and devices left in cars all weaken exact placement. Snow covered and moved evidence. Fresh accumulation can swallow plastic shards and blur tire marks. Plows push debris into banks. By dawn, the lawn and curb were not a clean slate. The car told an incomplete story. The right rear taillight was broken. Other panels lacked clear, matching damage. The housing did not show dirt or blood tucked inside. That gap mattered. Injury science had two lanes. Blunt force head trauma can follow a vehicle strike or a backward fall. Frozen ground can be hard as concrete. Hypothermia can change how injuries look and how fast blood pools. The legal point was simple. The state must prove its claim beyond a reasonable doubt. Doubt is not a hunch. It is a reason that makes you pause. If the timeline is fuzzy, the physical scene is mixed by a storm, and the science points two ways, then doubt is enough. Jurors do not balance theories. They ask if the state's story is sure, not just likely. The state's pushback, answering cover-up claims. Prosecutors stuck to their core. They said Canton Reed hit John O'Keefe with her SUV after a night of drinking, then left. They met the defense head-on. Their main answers. Keep the SUV theory intact. A broken taillight, proximity at the drop-off, and impact-style injuries fit a curbside strike. Snow can hide shards, but it does not erase a fatal hit. Dismiss cover-up claims as smoke. They argued there was no proof of a plot by people inside the house or by police. Missteps in an investigation, they said, do not mean a conspiracy. Use motive and behavior. Alcohol, strained messages, and late-night calls painted a picture of anger and loss of control. They told jurors to connect human behavior with physical evidence. Face the misconduct head-on. A fired investigator raised real concerns, but prosecutors pressed that the bulk of evidence stood apart from his conduct. They urged jurors to look at the record, not headlines. In cross, they pressed defense experts on assumptions. Models need inputs. If you accept a fall theory, you also accept a chain of events that left a man outside in a blizzard. They argued the simpler story was the SUV. Jury instructions and burden of proof. The judge's directions gave jurors a map. The words were not abstract. They explained how to sort complex evidence without guessing. Reasonable doubt means a fair and strong hesitation. If something real makes you unsure, you must acquit on that charge. It is not beyond all doubt. It is beyond reasonable doubt. The burden stays on the state, always. The defense does not have to prove a different story. Raising a real question about the state's story is enough. Each charge stands on its own. Jurors weigh murder, manslaughter, and leaving the scene separately. They can find different answers for different counts. Evidence quality matters more than volume. If key proof is unclear or unreliable, that matters more than how many witnesses said it. These instructions let jurors walk through the mess of winter evidence, clashing experts, and phone data. They could accept part of the state's case, like alcohol use, yet reject the fatal hit. That is how they reached split outcomes in 2025. Not guilty on murder and manslaughter. Guilty on OUI with probation. The map worked as designed. High certainty for the most serious claims and a separate, lower bar for the driving offense. Verdict, sentence, and what comes next. The 2025 finish drew a clear line. The jury rejected the state's fatal hit theory, yet found that alcohol and driving still crossed the legal line. That split outcome is not rare in hard cases with cold facts, clashing experts, and winter noise. It reflects how jurors sort different elements, count by count, rather than vote on one story. Mixed outcome explained. Not guilty on homicide, guilty on OUI. A jury can clear a defendant on the top counts and still convict on OUI. Each charge has separate elements. The state must prove every element of each charge beyond a reasonable doubt. If jurors find a gap on cause of death or who caused it, they must acquit on homicide. If the evidence still shows the person drove under the influence, they can convict on OUI. Here is why that can happen when the cause of death is disputed. The homicide counts rise and fall on proof that the SUV caused the fatal injuries. If snow, missing debris, and split experts create real doubt, the law says acquit. OUI asks a different question. Did she operate a vehicle after drinking to a level that impaired her ability to drive safely? Jurors can answer yes based on testimony, video, or admissions, without tying that driving to a death. Think of it as two tracks. The first is about a death and its cause. The second is about impairment and operation. In this case, the jury found the first track too uncertain and the second track clear enough to convict. That is how you end up with not guilty on murder and manslaughter and guilty on OUI. What the 24D program and probation mean. Massachusetts uses the 24D program for many first offense OUI cases. It is a structured plan that focuses on safety, change, and accountability. Courts pair it with probation. So the program is not just a class. It is a monitored path with real stakes. The 24D basics usually include education, alcohol or substance education sessions that cover decision-making, risk, and relapse prevention. Treatment, screening by clinicians, with referrals for counseling if needed. Some people do group sessions, others add individual therapy. Supervision, regular check-ins, program attendance tracking, and reports to probation. Probation ties the whole plan together. While terms vary by case, common rules look like this. Report on time to a probation officer. Stay arrest-free and follow all laws. No alcohol or drugs unless prescribed and disclosed. Random testing can apply. Complete the 24D program and any counseling or panels the court orders. Pay fees and assessments on schedule. Obey license restrictions set by the RMV, including any ignition interlock requirements tied to a hardship license. Travel only with approval if probation limits out-of-state trips. What happens if rules are broken? Probation can file a violation notice. The court holds a hearing. The judge can add conditions, extend probation, or order community service. For serious or repeated violations, the court can impose a harsher sentence, which can include time in the House of Correction. Completion brings closure. Finish the program, pay what is owed, and probation ends. In this case, the court set 1 year of probation with 24D participation. That fits a first offense OUI outcome in Massachusetts. It is a second chance, watched closely. Possible aftermath: motions, civil claims, and reviews. High-profile cases do not end at sentencing. They ripple. Here is a practical roadmap of what can follow without guessing outcomes. Post-trial motions on the OUI. Defense may challenge parts of the conviction or sentence. Common filings target evidence rulings, jury instructions on OUI, or the sufficiency of proof on impairment. Appeal of the OUI conviction. If the defense believes legal errors affected the verdict, they can appeal. Appeals take time and focus on the record, not new evidence. License and RMV issues. Separate from court, the RMV sets suspensions and hardship rules. Lawyers often handle RMV reviews in parallel with court obligations. Civil lawsuits. The O'Keefe estate could file or continue civil claims for wrongful death. On the defense side, a defendant can consider claims against agencies or individuals, like defamation or malicious prosecution, if lawyers see a basis. Public records and audits. Reporters, advocates, and defense teams often file public records requests to test how evidence was handled. Towns or state offices can order outside reviews of investigative steps if confidence was shaken. Professional discipline. If testimony or conduct raised flags, licensing boards or internal affairs units may look at experts, officers, or lab staff. Outcomes can include retraining or discipline. Legislative or policy review. High-profile trials can spur hearings on evidence handling, digital records, and how agencies coordinate during winter scenes. This is common when a fired investigator or process gaps draw attention. Community response. Victim support services, local forums, and university panels often host events to process the case. These are not legal steps, but they shape the public record. The path after a verdict is part legal, part administrative, and part public trust. For the Karen Reed case, the homicide chapter closed with acquittals. The OUI chapter continues under probation and 24D, and the broader process questions remain open for review. What this case means for trust, media, and future trials. The Karen Reed verdict did more than settle charges. It pushed hard on trust, how we read the news, and what high-profile trials should look like next. When evidence splits, process becomes the story. Clean work builds confidence. Sloppy work breaks it. This case is a reminder that fairness is not a vibe, it is a record you can audit. Evidence handling and openness build trust. Trust starts with the basics. If the public can follow the chain from street to storage to courtroom, faith rises. If links are missing, everything shakes. Why it matters. A clean chain of custody shows who handled each item, when, and why. It protects the evidence and the people involved. Full discovery lets both sides test the same record. No surprises, no hidden files. Clear reports help jurors and the public understand methods and limits. Plain language beats jargon every time. Common sense steps courts and police can take. Standardize the scene. Use body-worn cameras during collection. Photograph items in place, then again during packaging with visible labels. One item, one path. Assign a single evidence ID, sealed packaging, and a barcode that logs every handoff in real time. Public logs without sensitive details. Publish a redacted evidence index with timestamps and testing status. Share updates when tests are added or repeated. Discovery on a clock. Set hard deadlines for turning over files, lab notes, device logs, and raw data. Late additions should trigger a hearing and a written reason. Independent checks. When a lead investigator is disciplined or fired, order an outside review of any step they touched. File a public summary. Method sheets in English. Forensics reports should include a short plain language section. What was tested, what was not, and the margin of error. Digital truthfulness. Produce original device data and verification hashes. Provide tool versions, settings, and known limits. Training that sticks. Winter scenes, digital drift, and cold weather forensics deserve hands-on refreshers. Skill beats guesswork. These are not fancy upgrades. They are routine habits that protect cases from doubt and people from rumors. Media heat versus fair trials. Headlines travel faster than transcripts. A sharp title or a viral clip can set a story before facts settle. When a case becomes content, bias creeps in. How coverage can sway views. Selective snippets. 10 seconds of a cross-exam clip can hide the context of a full hour. Speculation framed as fact. Phrases like sources say, or people close to invite belief without proof. Meme logic. A chart, a map, or a zoomed photo can suggest certainty where none exists. Volume over quality. The most shared thread is not the most accurate one. Simple tips to spot rumor versus record. Who is the source, and are they named? Anonymous quotes need extra caution. Is there a document? Look for filings, orders, or sworn testimony you can read. Are numbers and timestamps clear and consistent? Vague times invite spin. Does the piece separate facts from views? Look for words like the filing states versus experts believe. Are corrections posted? Honest outlets fix errors in public. Smart readers carry a short checklist. Ask, where did this claim first appear? Check, does a filing or transcript back it up? Compare, do at least 2 independent outlets agree on the same fact? Pause, is the strongest claim built on a single unnamed source? Courts can help here as well. Fast access to filings, same-day audio or video of hearings, and consistent media guidelines cut down on rumor and guesswork. How to follow high-profile cases without getting lost. Big cases reward slow reading. If you want a fair view, build it from the record. Start with filings, watch sworn testimony, and read the judge's instructions. They frame what counts and what does not. Practical ways to track a case. Read the charging documents and any changes to them. Elements of each charge guide what matters. Watch sworn testimony when possible, not just clips. Tone, pauses, and full answers matter. Keep a simple timeline of key timestamps from filings and exhibits. Add weather, traffic, or known delays if relevant. Save jury instructions. They are the rulebook the verdict must follow. Note what is stipulated. Agreed facts are anchors you can trust. Use these quick prompts as you read or watch. What is proven? What is opinion? What is still missing? What changed since the last hearing? What is the source, and can I read it myself? A short example helps. A claim says a phone ping puts a person at a curb. Proven, only if the record shows precise GPS with error margins. Opinion, a commentator saying that seals it. Missing, the device settings, the app's accuracy, and weather effects. High-profile trials test patience. Keep your own file, date your notes. Mark what comes from court versus commentary. When the verdict arrives, you will know why, not just what. A winter night, a hidden lawn, a town on edge. The story began with a death in a snowstorm and grew into 2 trials that tested trust. The final result was split. Karen Reed was found not guilty of murder, manslaughter, and leaving the scene, and guilty of OUI. The sentence was 1 year of probation with the 24D alcohol education program and a license suspension during it. That outcome matched the record the jury could trust, not the noise around it. What lasts is the debate. The science pointed both ways, the snow blurred lines, and doubts about process stayed loud. The verdict closed the most serious charges, but it left a call for better work. Clean scene logs, full discovery, and clear reporting should be the norm. Evidence quality is the backbone of public faith. Carry this forward with empathy for both families. Respect the verdict, the juror's task, and the limits of winter proof. Stay curious, check sources, and hold to the record you can read. If you found this useful, share it, then watch for audits, filings, and policy fixes. Facts first, patience next, and the truth in view.